Well, welcome to the afternoon session. I hope you enjoyed your lunch. The first session that we're going to be doing this afternoon is on foreign direct investment. Foreign direct investment is quite different from trade in terms of the way it's set up. I'm sure most of you know, but there's no World Trade Organization. There's no general agreement protecting foreign investment. There's bilateral network, and governments around the world have always had a very large role in both inward foreign direct investment and outward foreign direct investment. So it should be a very interesting session. My own area of interest is petroleum. The largest producer of petroleum in the United States is not Secretary Tillerson's former firm, but in fact, British Petroleum, just as an example. We have two great speakers, Michael Smart and Professor Maggie Chen, and I've asked them each to keep their remarks to 15 minutes so that we have chance for questions, and especially with so many people here, I'm sure there will be many, many questions. There may not be as many answers. With that, I think we should start. You have their bios, and so we'll ask Mr. Smart to please come up. Thank you.
Thank you. Thanks, Professor Moore, for the invitation to participate here and to the Institute for sponsoring. Trumping trade orthodoxy is spot on. We're certainly in a period here where there's no principle, no institution taken for granted. Everything is open to questioning, which makes this a very interesting conversation. In that context, I'm going to try to cover two topics. One, taxes, and by that I mean border taxes, as our president uses that word, as well as a little bit on border adjustment taxes, as well as international investment agreements, and by that I mean bilateral investment treaties and the investment chapters of U.S. free trade agreements, and leave lots of time for questions. So, border tax. As a candidate, as president-elect, and now as president, Trump is famous for his tweets vowing to impose a border tax, 35% border tax on those companies that invest overseas and export to the United States. He's gotten quite a reaction to these tweets. Companies are dying to stay out of the crosshairs. They're reconsidering investment plans, in some cases altering investment plans. But I think for us, we should think about, well, does he actually have this authority to carry out the threat? And it's simple, but I think important to remember that the Constitution gives plenary authority to Congress to raise taxes, raise tariffs, and regulate commerce, foreign and domestic. So we have to be very specific as we try to answer that question. And frankly, in recent months, people have been dusting off some very old statutes because this kind of delegated authority does exist, going all the way back to the Tariff Act of 1930. And so you can create this inventory and try to match these authorities against what the president is talking about. President can restrict imports that threaten to impair national security, the Trade Expansion Act of 1962, to deal with the large and serious balance of payments deficit, Trade Act of 1974, to deal with unjustifiable foreign government practices that burden or restrict U.S. commerce, Section 301. So normally something that we adjudicate through the WTO, but we know this administration has a different view about whether that's necessary. So you can go through this inventory, and it's important because, again, he's raised this issue in lots of different contexts. But what I would say about the specific issue of calling out companies that invest overseas intending to export to the United States is these statutes don't support that. The one area that I think perhaps deserves a closer look is IEPA, the International Emergency Economic Powers Act. This law gives very broad authority, and it gives the authority to target specific companies and even specific individuals. It's the authority that we use, for example, to impose sanctions on various Russian entities and individuals following the invasion of Crimea. So the authority is broad. You can block transactions in foreign exchange. You can prohibit transfers of financial payments. You can freeze assets. Now, it's not been used, as far as I know, to actually raise tariffs. But certainly the terms of the statute are broad enough. It gives the president the authority to regulate the importation of any property in which a foreign country or national has an interest. That's an important part. So in order to invoke and use these authorities, the president first has to declare a national emergency, which is defined as an unusual and extraordinary threat arising wholly or in substantial part from overseas, outside the United States. So is it conceivable that the president could identify the loss of manufacturing jobs as a national emergency? And I should say that it's a threat not just to national security, foreign policy, or economy of the United States. And I think that there is very little to suggest that if this action were challenged, a court would be likely to look and review the actual merits of that determination. Because the way IEEPA has been used, clearly there are circumstances that by the ordinary meaning of unusual and extraordinary threat wouldn't really meet the definition. I mean, to sanction individuals in Sierra Leone, for example, or more recently, Obama administration, certain individuals guilty of human rights violations in Venezuela. But I think that doesn't necessarily mean that a court would just defer entirely, because there would be some scrutiny given to the relationship between the emergency as the president has defined it and the nature of the measure that he is imposing. And there, I think it would be difficult to argue that the instances of outsourcing of U.S. production to certain foreign countries is really has a rational relationship to the loss of manufacturing jobs in the industrial Midwest, which, as you were discussing earlier, is caused by a whole host of factors. The other piece that would make this vulnerable, I think, what I mentioned before, is would the imported good, in fact, be something in which a foreign country or national had an interest? When you're talking about the importation of goods and a tax levied on the importer, I think that then becomes a difficult prong in the analysis for anyone who would be defending that action. I think we're probably giving more rigorous analysis to this question, maybe than those who are proposing the action. But it is still important, because I think it's very important. Why are companies responding? They're responding to stay out of the crosshairs. They have reputational concerns at stake. But how long that continues depends very much on the political situation. And absent a clear legal instrument to carry out this, I think you could see that we'll have diminishing marginal returns. Okay, so in this context, border taxes, withdrawing from pending trade agreements, renegotiating NAFTA and other existing agreements, into this combustible mix, we have kind of rekindled maybe the oldest U.S. grievance under GATT rules, the WTO, which is border adjustability of taxes. This would be controversial at any time, but coming as it does right now, I think explains part of the very strong reaction. And the reaction actually has been more limited really to affected U.S. importers so far. I mean, I think the foreigners are taking a little bit of a wait and see attitude here, and knowing that if sort of they jump into the mix, is likely to hurt their cause as help, kind of given the current environment. But let's get to the issue. So this has been an issue of longstanding concern. It's been dormant for at least 10 years because the rules are pretty clear that if you're going to adjust taxes at the border, and you can do that only with respect to so-called indirect taxes, those that apply to goods generally. And that the U.S., sticking closely by its taxation of income regime, both on the individual side and for corporations, could complain about that as being unfair, But now we have a vehicle to carry this debate to kind of the next step, which is the House Republican tax reform blueprint, which would make pretty fundamental changes to the corporate tax system. And the sponsors argue, take it from a taxation on income to a taxation on cash flows, which should be adjustable under WTO rules. I'm not a tax expert, but let me just say that I think that those who argue that this still retains core features of a taxation on income regime have a pretty good point, which would make this a violation under any circumstances. But even if you take the sponsors at their word that it's an indirect tax, there is a discriminatory feature to it, and you probably have heard that it involves the deductibility of wages. So this, I think, has a difficult road ahead for reasons mostly unrelated to what I'm talking about, but it's really domestic politics. But if this ever were to get to the dispute settlement phase, the size and magnitude of this dispute would dwarf anything we've ever seen before. Estimates are that this would raise approximately $110 billion annually. That's 3.5 times the amount of revenue we raise from tariffs currently, and multiples of the value of any previous WTO dispute. Let me jump ahead quickly because I want to talk a little bit about investment agreements. FTAs have been the center of the discussion, NAFTA, TPP, et cetera. But there's this other really important feature of our international economic architecture, which are bilateral investment treaties and FTAs. What's going to happen with Trump? Well, I just talked about how Trump, will threaten companies that actually invest abroad and export to the United States. So why in the world would he want to negotiate treaties that improve investment conditions for U.S. firms? I would make the argument that he's going to have actually a much broader understanding of what U.S. Investment abroad means. And certainly the facts bear this out. If you look at total sales by foreign affiliates of U.S. firms back in 2013, something like $5.7 trillion, less than 10% of that was sales into the United States. So he is focused on kind of a sliver of this investment profile. And then when you look at sort of the flip side, you know it's a source of strength. I mean, these companies account for something like 50% of U.S. exports, 85% of U.S. R&D, 2/3 of U.S. employment. The fact that firms out there are invested in the world is a source of strength for our economy. And certainly Trump, with all of his business experience, should understand that. You can't serve hotel customers in Dubai by opening a hotel in Philadelphia. And you don't take jobs away from hotel bellmen in Philadelphia when you open hotels abroad. So I think that at some point he will see this as an area of where he has authority that he can exercise for the benefit of the U.S. economy. And the first example of that will be the bilateral investment treaty with China. This is something that was launched back in 2008. Reached a very advanced stage during the Obama administration, did not conclude. But, we're, I think, waiting right now for the China agenda to roll out. And certainly this administration is going to have a different, tougher policy, no doubt about it, whether it's trade remedies, treatment of inbound investment, et cetera. But I think a convincing case can be made that the U.S.-China bit advances his goals. What does the president often complain of? They don't treat us fairly. What does that mean? We treat them better than they treat us. A bit would go a long way to addressing that. I mean, one of the best examples of this inequity is this surge in inbound investment that we've seen from China in sectors where we're not even eligible to invest. And so he doesn't call it reciprocity. It's treating us fairly. That's exactly what a bit would do in terms of opening market access. Concern about state-owned enterprises operating behind this protected wall, using that advantage in global markets. Again, by opening them up to competition, that sort of rent-seeking they're able to do in the Chinese market is no longer something they can deploy when they go out in the global economy. protecting IPR, forced transfers of technology. All of these things are tools in a bit that could be used to address these kinds of concerns. So I flag investment agreements because it's an important piece of the architecture. I think somewhat thankfully has flown below the radar to an extent, but I think there is a strong argument to be made that it can help advance some of the policy areas that this administration seems to be concerned about. Thanks very much.